Just lower the microphone slightly. I am standing up, by the way, which only marginally increases my height, but it helps a little bit. It's my pleasure, it really, really is, to be here on such a special day for all of you. And I feel very excited about the atmosphere at this conference and the atmosphere in your country today. In fact, I have been contemplating staying and claiming asylum because, as you may have detected, the human rights conversation is slightly less inspiring and positive back home at the moment. And so, you know, the idea of a human rights campaigner claiming asylum in Dublin is not quite as ridiculous as you might think. You'll know, I hope, that I work at Liberty, the National Council for Civil Liberties back home, founded in 1934, completely different time from 2011, of course. 2 years couldn't be more different in history, could they? 1934, time of great economic uncertainty. 1934, a time when some of our newspapers in London would regularly run headlines about the country being swamped by refugees from Eastern Europe. 1934, the long shadow of the First World War, and the second one to come. War, conflict, the rise of the far right in Europe, again completely different from 2011. And the particular impetus for the founding of my organisation was the hunger marchers who came from the north of England to Hyde Park in London and were promptly duffed up by the Metropolitan Police. And of course that too would never happen today. So there we go, completely irrelevant history lessons. But what is important is that in the 77-year journey of Liberty, perhaps the most important moment on the road for us as an organisation was when we moved from thinking about our work in terms of domestic civil liberties, leave me alone over McQueen Estate, don't bash me over the head with the policeman's truncheon and all of that, to actually finding ourselves as part of a wider international human rights consensus. The journey from simple liberty to something more positive and protective and universal, human rights. And that's a journey that took some time, in truth, even for my own organisation. It seems to be, however, taking a little longer, unfortunately, for my country. And I think that the initial resistance to having any kind of Bill of Rights in the UK was a resistance really founded on a certain complacency. The complacency that came from being, you know, a pretty old, stable, unbroken democracy, at least in terms of people on the mainland, if not people elsewhere around the world, feeling pretty confident, feeling pretty smug, that bad things would never really happen, and that Britain didn't really need a Bill of Rights. Bills of Rights were for younger democracies elsewhere, places where bad stuff happens, you know, like torture and disappearances and punishment without trial, and huge intrusions into privacy, the sorts of things that could never happen in mainland Britain. Now that complacency, I do believe, ended with the terrible excesses of the War on Terror. So I don't think that the current toxic debate, and it is often really quite a toxic debate about the Human Rights Act, and whether it should be replaced with, and I quote, a more British Bill of Rights and responsibilities with common sense. I don't actually believe that even the toxicity of that debate is fueled anymore by complacency, because even the right sceptics, even those who want to do down the Human Rights Act and scrap it and replace it with something less, have to concede that there's got to be a Bill of Rights. So to be slightly positive, that is a development. People had to accept, after 9/11, with some of the astonishing authoritarian excesses that followed, that parliamentary sovereignty unchecked by human rights principles was not going to protect even any notion of ancient liberties in England. Wasn't going to cut it. Didn't cut it. Wouldn't have protected people from internment, which is what happened in Belmarsh after 9/11. If you think back to that landmark case, perhaps in a way the most, the landmark case in the early years of the turbulent infancy of the Human Rights Act. But for the Human Rights Act, which I know lacks some of the tougher enforcement powers that come in other constitutional instruments around the world, even with the Human Rights Act, it's rather a delicate compromise between the rule of law on the one hand and parliamentary sovereignty on the other. The Human Rights Act was the only way that those men in Belmarsh prison could ever have got access to the court door. Because who could have thought in my lifetime that a British government and a British Parliament would pass a statute that said not only that people who've never been interviewed by the police, never been properly arrested or charged with anything, could spend the rest of their lives in Belmarsh prison, and would out the jurisdiction of the courts to even look at that policy, to even consider it, to even participate in the national debate about whether a measure like that was acceptable. Because that's what the statute did, let us not forget. It said there will be no habeas corpus. There will be no judicial review of the Home Secretary's decision to place someone under this regime. Absolutely astonishing. But for our modern Bill of Rights, the Human Rights Act, there would have been no proper judicial scrutiny whatsoever of that policy. And I think, therefore, it's a good job that the complacency is no more. And a lot is said about public opinion and public scepticism towards the Human Rights Act in Britain. And of course this is said in the media. And the media has its own interests in this conversation, which I'll come to in a moment. But to be, again, more positive, we at Liberty regularly poll British public opinion towards fundamental rights and freedoms. And we've been asking the same 3 questions to a sample of over 1,000 people in Britain about every 6 months for the last few years. And the first question is, do you think that it's important that there is a law in Britain that protects everyone's fundamental rights and freedoms? Do you think that that's important? There should be such a law. And the answer comes resoundingly. 90+%, it varies between 93 and 97% of those regularly polled say yes, it's important. And the second question involves listing the actual contents of the ECHR and the human rights, the actual component rights and freedoms: no torture, free speech, fair trials, rule against arbitrary detention, equal treatment under the law, freedom of thought, conscience and religion, protection of property, and so on, personal privacy, right to respect for your family life. Do you think that the following listed fundamental rights and freedoms are vital or important or trivial and unnecessary?